All who have business before this court draw near, give attention, and you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Okay. Good morning and welcome to the First District Court of Appeal. This is kind of a special session because it's the first live oral argument this court has seen in about a year and a half. And I checked yesterday and found out that it's actually the first live appellate oral argument in the state since last March. So because it's such a red letter day, we're going to have a break between the arguments and meet for coffee in the rotunda, and we invite counsel to join us there. So without further ado, we have two cases on the docket today. The first is Green Technologies versus Harslev Incorporated. 15 minutes per side has been allotted. Are both sides ready to proceed? Thank you. Appellant, you may approach.
Good morning. My name is Stacy Blank, and I'm here today on behalf of the appellant, Green Technologies. I would like to reserve 3 minutes of my time for rebuttal.
So noted.
Thank you. Green Technologies' arguments in this case are simple and straightforward. Florida courts have long held that a party is not required to submit a dispute to arbitration unless it has agreed to do so. In this case, the trial court disregarded basic legal principles of contract formation in finding an agreement to arbitrate. First, the trial court ignored Florida law requiring that an acceptance be the mirror image of the offer. A response to an offer that changes or proposes material terms is not an acceptance. It is instead a counteroffer that operates to reject the original offer. In this case, the trial court found that the parties' contract was the October 17th proposal sent by Harslev. The Green Technologies never accepted that proposal. Instead, it responded by changing the price and delivery terms and by adding the requirement of a performance bond, an entirely new essential term that was absent from the proposal. By changing and adding terms, Green Technologies did not accept the proposal. Its response had the legal effect of rejecting it and extending a counteroffer.
Counsel, I've seen this argument in your briefs here, and I understand your response to appellee's contention that it was not preserved. My concern is when I look at the order by the trial court, I don't see any reference to the point that you're making. So while I understand that you may have made this argument in the proposed order and a couple of other places, was it made to an extent that the trial court would have considered it?
Well, I think so. I don't know what the trial court considered and didn't consider. The thing that is somewhat mystifying to me is the trial court specifically notes that there were 3 changes from the proposal to the order confirmation, but he doesn't note the performance bond as being one of those, even though he quotes the letter of intent from Green Technologies that says, please consider this our, intent to accept contingent on the inclusion of a performance bond.
But did you ever specifically argue to the trial court that the performance bond was a changed material term that negated the offer?
We did.
On what page of the transcript or the record? What page specifically?
Sure, let me, so the first place is in the pretrial memorandum of law, which is at page 1504 of the appendix, and it's in footnote 2. It says the documents, and it's talking about the proposal and then the order confirmation, contain material substantive differences in their terms, such as liability issues and passing the risk of loss. This is a performance bond. And then more specifically, in the proposed findings of fact and conclusions of law, and that's in the supplemental appendix, there's statement that says, Mr. Hamilton also added that upon execution, Harslev would provide a performance bond, a material addition resulting from the parties' negotiations. Then, one thing that I think that the court might also want to note in the Triton case that we cited, the court considered a very similar issue. In that case, the defendants, like Green Technologies here, argued that there was no enforceable agreement because the parties had left essential terms open for further negotiation. The plaintiffs, on the other hand, argued that the defendants had not preserved that argument below. And the appellate court explained that this is a sufficiency of the evidence issue, and it is not required to be preserved for appeal. It can be raised for the first time on appeal. So precisely the same issue that we have here, and the appellate court in Triton said, this is one of those issues that you can raise for the first time on appeal.
Counsel, your almost your entire initial brief relies on the idea of meeting of the minds and other common law contract principles. It's only in the reply where you address a little bit the UCC aspect, which is what your opponent argues quite a bit. And then you make the you take the position that it really doesn't make a difference. And I want to break those down and first hear your argument as, or can you explain a little bit more as to why you don't think the UCC applies here?
Sure.
And then my second question will be, can you explain a little bit more as why you don't think it makes a difference? Because it seems like it actually turns on that. Like UCC applies, you lose. It doesn't apply, and you perhaps win.
Okay. So the first reason that I would say that the UCC doesn't apply is the section that Harslev relies on, 672-207, only applies to transactions between merchants. And Green Technologies is not a merchant as that term is defined under the statute. In fact, the statute says that a merchant is, if you'll bear with me, I'll read it, one who deals in goods of the kind or otherwise by occupation holds himself or herself out as having knowledge or skill peculiar to the practices or goods involved in the transaction. But Green Technologies doesn't deal in industrial dryers, which was the good involved in this transaction. And Harslev never presented any evidence below suggesting that it had any particular knowledge or skill. To the contrary, this was the first time it had ever bought an industrial dryer. And the trial court found in its order that, in fact, Green Technologies had never dried its own biosolids. Always in the past, it had purchased those from third parties.
Well, let me drill down into that a little bit, because that's where I wanted to take you. Is okay. So your client hasn't bought one of these before, but they certainly spent a fair amount of time negotiating some very esoteric details about. I didn't know much about dryers before. Know a little bit more now. How can you argue that your client didn't know anything about this particular type good when they're sitting there negotiating for over a year the specs on the dryer?
Well, I could just offer a similar example. I anguish a lot over buying a car. I, shop, I negotiate, I try to read up, but I'm certainly not a dealer in cars, even though I negotiate for a long time and try to educate myself. So, the statute says, you have to be a party who has extensive skill, knowledge, experience, and you deal in this commodity. And, there is just no evidence suggesting that Green Technologies was a dealer. And, I think Harslev says that they're a commercial party, and so therefore that equates to being a dealer. But that's not what the statute says.
But isn't it correct that they were awarded a contract by Gainesville Regional Utilities to dry the solids, and certainly in getting that contract, they would have held themselves out that we can do this, we have the skills, we have the knowledge, and I believe Dr. Varshavy was, very experienced in, converting biosolids to the fertilizer. So
Well,
certainly I think this falls under the broad definition of merchant.
Well, I think that he was experienced in manufacturing fertilizer from biosolids that he had bought from others. This contract required them to expand into drying their own biosolids, and that was something that they had not done before. The statute, the UCC statute also doesn't apply because there's no battle of the forms in this case. The official comment notes that this statute is intended to address the situation where merchants exchange standardized forms as part of their contract, but those standardized forms include different terms. But here there was no exchange of standardized terms.
But the statute doesn't mention standardized forms, though, does it?
The official comment mentions it, the language of the statute itself does
Right.
not.
I mean, the legislature didn't enact the official comment. It
Right.
enacted the statute.
That's correct. That's correct. But in terms of context, that explains why the statute is not a clean fit here, because this was a negotiated agreement. They exchanged draft documents, they exchanged revisions, and they continued to negotiate until they reached a final agreement. You don't have a purchase order that comes over that has standard terms, and then an acceptance that's a pre-printed forms, and there's a conflict, which is typically where you see this section applied.
Is it a question of fact, though, as to whether Green Technologies is a merchant? Or is it
It
a question
probably
of law?
would have been a question of fact, but there's just no evidence in the record, I think, suggesting that they, other than the fact that they negotiated this single transaction for an extensive period of time. I mean, Harslev offered no evidence that it was an entity who dealt in industrial dryers or had ever purchased one before or had any particular knowledge or expertise. We don't even know, for example, whether as a result of these negotiations, they learned very much about dryers.
But could
Did you
the-
make this argument to the trial court that you weren't a merchant?
It was never raised before.
Okay.
Was the trial court free, though, to infer from, was it 2 or 3 days of evidentiary hearing, and how this transaction went down over the course of 18 months, 2 years? It's not like Green Technologies ever insisted at some point, okay, now that we've agreed to all the terms, we'd like your standard written contract. It's got 15 pages or it's 30 pages, and you sign on the dotted line at the end, like a standard contract. It seems like Green Technologies engaged in the same kind of UCC negotiation that you typically would expect in this type of situation. And so couldn't the trial court have inferred from that Green Technologies was expecting to consummate a transaction under the UCC?
I don't think this looks like the typical UCC transaction. I mean, there were no pre-printed forms exchanged. I mean, these were all, specifically negotiated terms. And, Green Technologies did not send back its standard purchase order that had competing terms. I mean, that is the typical UCC negotiation and transaction, and we just didn't have that here.
But Green Technologies never insisted on a final contract either. I mean, it never said, okay, now that we're done, send us the final contract with all the pages and, what you would typically expect to see in a standard contract. Instead, there was negotiating on specs and terms and back and forth on just different.
And I think that's exactly what takes this out of the UCC. I mean, typically in the UCC, you see a much more formal exchange of documents. And here we have the exact opposite of that. You don't have an exchange of their standardized forms and sort of a routine that they go through in doing these kind of, regular and routine bulk purchases.
But 672-207 also has paragraph 3, which talks about conduct by both parties, which recognizes the existence of a contract. Don't we have that here? I mean, it pretty much after the final proposal was sent, the letter of intent was sent, the parties started to perform under something that was a contract, correct?
Well, I think that is one of the problems is that the trial court, could shift quickly to, I think that the court made a couple of errors with respect to the fact findings on that and legal errors underpinning that. I mean, the parties' negotiations continued even after Harslev sent the proposal. And, Harslev's own internal communications confirm that. After they received Green Technologies changes, Harslev's president communicated to Hamilton and said, we need a final document with price and shipping terms. Then he wrote again, send me the revised proposal. This is after the proposal went to Green Technologies. And finally, he wrote to Hamilton again, change this proposal so it says order confirmation and doctor the text as you find needed. When you are done, send it to me for review before we send it, and it will serve as the final agreed document controlling this order. So Harslev understood quite plainly that negotiations were continuing even after the proposal had been sent. Those changes all were memorialized in the order confirmation, which Hamilton then sent to Green Technologies with the following cover. Following up on our conversation, I've provided a confirmation which we can use in lieu of an amended proposal. It addresses the performance bond and the clarification of freight terms that we discussed. So the parties' negotiations on these last terms continued. Before I'm out of time, I want to get back to the question that Judge Tannenbaum had about why it matters, whether it's the UCC or the mirror image rule. And the reason is, under the UCC, and this is in subsection 1, a response to an offer operates as an acceptance, even if it includes different or additional terms, unless the acceptance is expressly made conditional on the original offeror's assent to the additional or different terms. And that's precisely what happened here. In the letter of intent, Marla Buchanan said, Green Technologies, please accept this as our intent to accept, contingent on the provision of a performance bond. And so that, in essence, took it out of the UCC, where it says even if you propose additional terms, you still have an acceptance. It did not. It converted it into a counteroffer. And so even under the UCC, the response was a counteroffer and not an acceptance.
Thank you. Counsel, you're out of your rebuttal time, but because you got so many questions from the panel, we'll give you 3 minutes to wrap up, and if we could add 3 minutes to the appellee's time, we can even it out. Thank you.
Good morning, Your Honors. I'm Jeffrey Islander from New York. I represent appellee Harslev. I have one advantage that I bring here today over my opposing counsel, my adversary. I actually tried the case. And with respect to all of the issues you've been discussing this morning, none of this was raised during the trial. There was no issue regarding the performance bond. There was no issue regarding mirror image. There were no mirrors in our trial. There was no UCC. The trial concerned one or two factual issues. Factual issue number one is, was there a contract? What did the parties intend? And factual issue number two, which a lot of time was spent on, was Green Technologies informed of the Orgelheim rules? And the judge made factual findings. Respectfully, the way this case has been couched to this court at an appeal is it's as if there was never a trial. I mean, there are lots of legal arguments based on documents. It's almost as if we're pretending there was a summary judgment motion or a denial of a summary judgment motion. But that's not what happened. There was actually a trial. There was a 2-day trial. There were two key witnesses. There was Mr. Hamilton on our side. There was Ms. Buchanan on their side. And these two witnesses vociferously disagreed over what was the contract. And at the end of the day, the judge had to look each of the witnesses in the eye and decide who was telling the truth and who was not telling the truth. And he made that determination. And I think, the way these arguments have been couched, we're a little bit too much in the weeds, and we're forgetting this conceptual truth that what we're reviewing here is a credibility determination. This was a trial as to who was telling the truth, who was not telling the truth. And with all due respect to Ms. Buchanan, she came to the trial handicapped because when the case began, she submitted an affidavit where she swore up and down that she had never seen the Orgelheim rules. She said she never got them. And my colleague took her deposition, and at the deposition, she admitted, lo and behold, actually, I did get them. And the judge was informed of this at the time the trial began. It was not irrational for the judge, just on that basis alone, to find that Ms. Buchanan was a less than credible witness. But in all events, he heard her testimony, he heard Mr. Hamilton's testimony, and he determined that there was a contract, and the contract was the final proposal, what we've been calling the final proposal. That was the contract. I think the judge did not say this explicitly, but I think you can reasonably infer that he also found that Green Technology's story did not hang together. I mean, as presented on this appeal, what the story is that Ms. Buchanan receives the final proposal. She doesn't think it's a contract. Yet she marks it up. You know, she crosses out the euros, she puts in the dollars, she calculates what's owed under the dollars, she changes the shipping terms, and she sends it to Mr. Hamilton, and she says, I'm going to send you a deposit. Then she sends a deposit. All of this happened without the order confirmation being sent and without the order confirmation being signed. There was never any discussion of a performance bond, and if a performance bond was so important, these two parties were performing the contract. Green Technologies paid, Green Technologies received the device, Green Technologies continued to pay, and at no point does Green Technologies ever say, you know what, there's no performance bond. I mean, they're acting as if they are part of this contract, and I think that's, I'm not trying to be presumptuous, but I think that's what the trial court found most persuasive. Regarding,
But
yes, sir.
Do you agree, though, that when we're assessing on appeal whether the trial court got it right in concluding that there was a contract, that we need some rule of law to apply to make that determination?
Yes, Your Honor.
And we have two choices, it seems, I mean, roughly two choices. Either the UCC applies or the common law applies. And it still turn on that question of law, and you take the position that the UCC applies and governs this. Is that roughly where we are?
I would say that if we're going to assume that we're not going to just base this on credibility determinations, and if it's going to come down to whether it's the UCC or the common law, yes, our position is the UCC governs. In terms of the standard review, though, what I would say is that under Florida law, like anywhere else, whether parties intended to enter into a contract is a question of fact. There was a trial, and I would say that the most deferential standard of review should apply. Obviously, there has to be a rule. I think the rule is abuse of discretion. The trial judge made credibility findings. I don't think this is a de novo case. And in terms of whether the UCC applies or doesn't apply, the official comment, well, Your Honor yourself pointed out, we first start with the statute. And the statute and the commentary to the statute make it clear that basically as long as you're not a consumer, the UCC applies. In other words, as long as you're involved in some aspect of business that requires some kind of specialized knowledge, you're considered merchant. And there's no question that Harslev is a merchant. We sell these dryers. That's what we do. There's no question that Green Technology is, quote unquote, a merchant because in effect it's reselling the dryer. Okay, I mean, it's not literally selling the dryer to the municipalities, but it's providing the dryer as a service. It's not a consumer. It's holding itself out as having specialized knowledge in the business world. Under the UCC, therefore, it is subject to the UCC. And so, and this notion that there wasn't standardized forms, you know, frankly, is not true. At one point, Ms. Buchanan did ask Mr. Hamilton. There's an email where she says, "Send us your standardized forms," and he did. And that was, you know, all these proposals, they were pre-printed forms. I mean, there were specific details relating to this device, but there were also standardized terms. And yes, maybe technically it's true that she didn't send her own standardized terms, but they were working off one standardized term, and they were each, in a sense, marking it up. I think merchants do that all the time. It's not true in the business world that merchants are always sending each other forms. That would make no sense, obviously. I mean, at some point you have to work off of a common document. And the thing is they discussed everything. I mean, Ms. Buchanan is a lawyer. Okay, this came out during the trial. She's an experienced counsel. This thing went on for 14 months. They talked about everything except one thing. They didn't talk about the Orgelheim terms. Everything else that ever bothered her, everything else that she had a concern about, she raised. Okay, and it strains credulity that she, and this is on the very same page where it says general conditions and it says Orgelheim terms, there were other items that she constantly raised and made corrections to or asked revisions to. It strains credulity that she saw all that stuff, but she didn't see the reference to the Orgelheim terms. And as a matter of law, it doesn't matter whether she saw them or not. What matters is that she received them. That she chose not to read them, you know, frankly, is her problem. So, you know, everything except what matters was raised. I mean, that just is too coincidental to be true, and that again goes to a credibility determination.
Sure, but do you agree or disagree that I think your opposing counsel takes a position in the brief that it doesn't make a difference, like UCC, common law, whether you have a meeting of the minds standard or a UCC standard, it doesn't make a difference because they win either way. Do you take the same position that that you win either way.
I don't want to make your lives difficult, but I think our position is we win either way. Certainly we win if the UCC applies, and I think the UCC applies, because the question of whether the UCC applies turns on, are they both merchants? For the purposes of this case, they're merchants. They're both merchants. Even if the UCC did not apply, even if we were left with the common law rule, my understanding is that non-essential terms drop out. And under the UCC, opposing terms that are not objected to become part of the contract. Under the common law, terms that are not essential don't nullify the agreement. They just are not considered to be part of it. What are they saying were the changes? The performance bond. Obviously, that was not an essential term because they never followed up on it. There was never a performance bond, and they paid hundreds of thousands of dollars, in fact, frankly, over $1 million. They never objected about the lack of a performance bond. The other two changes, the shipping was for the benefit of Harslev. Harslev did not have an issue with it. And the other thing was the conversion of the purchase price. The purchase price didn't change. It was just a currency conversion. You know, by definition, these are not essential terms. So I'm not trying to avoid answering the question. I mean, if the court feels that it needs to determine whether the UCC applies, I think as a legal matter, the UCC applies. But I would also say that in a sense it doesn't matter. And frankly, even if we lose on everything else, even if the court for some reason were to determine that the order confirmation was the contract, order confirmation referred to the Orga-Lime terms. It referred to the, under Florida law, you can be bound by terms that are referred to in another document as long as they're sufficiently described. The order confirmation sufficiently describes the Orga-Lime terms. It doesn't matter if you're talking about the 2012 or 2010 or 2014. The Orga-Lime terms are standardized, and the two key terms we're concerned with here is the arbitration provision and the limitation on damages. I mean,
But what was attached wasn't the Orga-Lime general conditions, it was the supplement, which does not have the arbitration provision.
Respectfully, I don't think that matters, because Your Honors, if you look at the order confirmation, the order confirmation says under general condition Orga-Lime terms. If you then look at the attached, it says supplemental terms, but obviously supplement has to be supplement to something. There has to be an underlying thing. I would submit that the attachment of the supplement terms is a Scrivener's error. And if you look at the actual agreement, or assuming it is the agreement, we maintain that that's not the agreement, but even if you look at that document refers to Orga-Lime terms. And the Orga-Lime terms never change. No matter what year you're looking at, the terms are always the same.
Help me understand that. So on the sort of related to that question, so if we're just operating under common law rules and trying to figure out whether there's a binding contract, we have a mess of documents back and forth taking place over a large span of time. You know, revision 5, October 2016, or is it November, or just a series of these piecemeal documents, and there's never like an actual written contract signed by both parties. Just a sort of a self-contained, here's your final document type of contract. Help me understand why, even under common law rules, that definitively that you have a contract that clearly incorporates by reference the Orga-Lime terms, and that was agreed to by Green Technologies.
There are a lot of documents over a 14-month period. But if you look at the chronology between October and December 2016, that gives you the documents that form the contract. And the chronology is what creates the contract. On October 17th, Ms. Buchanan received the final proposal. On November 9th, she said that she wanted to make minor changes, but she was accepting the proposal. On November 21st, and this is the key date, if you're looking for one document, she sends the signed copy of the final proposal, proposal number 5. She takes the signature page, she signs it, she crosses out the amount in euros, she translates that to the amount in dollars, she changes a shipment term, and she sends it. That is her acceptance of the final proposal. That is the contract. She's the party to be bound, and she signed on behalf of Green Tech Technologies. More than that, on November 29th, Green Tech made the down payment. They paid $68,000. and then they made subsequent payments. So I understand, like, looking from a larger view, this is a morass of documents and it's kind of a mess. But if you look at this time period, there is a meeting of the minds, and more than a meeting of the minds is performance. I mean, part of the reason why this case, I think, is somewhat confusing is the arguments don't fit the facts. Like, all the arguments that are being made by Green Technologies would work in a situation where there was never really a contract. Like, in other words, if the deal had fallen apart and nothing had been sold, and you're wondering, okay, was there ever a binding agreement? These arguments might make sense. But the problem with this case is that they acted as if there was a contract. In other words, for all that's being said now about what happened in the past, at the time, contemporaneously, Ms. Buchanan accepted, we're not just talking about silence, she took affirmative steps to indicate that there was a meeting of the minds and that she believed there was a contract. I mean, they sent a $70,000 down payment. Who does that if you don't think there's a contract? She made subsequent payments. She went to her bank and she told her bank a year later, this is the contract. I mean, Your Honor, if you're, Judge Tannenbaum, if you're looking for the single document, I would say let's go with her own admission. She sent the bank her signed, her signature on that final proposal from 11/21. And that is her representation as to what the final contract is. So I agree with you, there's not a single document where the parties both signed at the same time. That's the integrated document, but you don't need to have that to have a contract. You can have a contract from various documents, you can have a contract from conduct, and that's what we have here. Right, thank you very much, Your Honors.
Thank you.
I'd like to start where my opposing counsel left off. If we want to look at what the parties said about what the contract was, we only have to look at Harslev's arbitration demand and its motion to compel arbitration filed in the trial court in this proceeding, where it said it cannot be disputed that the parties' contract was the order confirmation. And in fact, it drops a footnote in its legal memorandum saying that its provision of the 2014 Orgelheim conditions that it now relies on was inadvertent. It never intended to send those to Green Technologies. Throughout the entire course of the negotiations, Harslev referred to the 2000, 2010, 2012, 2012 supplementary, and the 2014 Orgelheim conditions. Green Technologies believed that it had satisfied whatever duty it had with respect to those conditions when it got back the final order confirmation, and attached to that were the supplementary conditions. Harslev's own witness, Mr. Hamilton, testified that all the references in the order confirmation to the Orgelheim documents related to the supplementary conditions, and the supplementary conditions have no arbitration provision. Harslev makes much of the trial court's factual findings, but Judge Tannenbaum's question is exactly right. Those fact findings have to be made against the framework of correct legal principles, and that's where the trial court got derailed here. Counsel also argued that this case doesn't turn on the documents at all, but rather on questions of witness credibility. But in fact, that's not accurate, because it is the documents that control whether or not the contract at issue is the final proposal. And that's very important to Harslev, because if it's not the final proposal, then those 2014 conditions, those 2014 Orgelheim general conditions don't apply, and there is no governing arbitration provision.
What's your response to Mr. Islander's assertion that, assuming the order confirmation is the contract, the supplemental conditions were attached, but the fact that you're attaching supplemental conditions that acknowledge these supplement the general conditions, that contemplates that the 2012 general conditions apply, and y'all had been provided the 2012 general conditions. So what's your response to that?
So I guess my first response is there were a lot of Scrivener's errors in this case by the party who had the burden of eliminating ambiguities and proving the existence of an enforceable agreement. What Mr. Hamilton testified was that all of the references in the order confirmation to Orgalum were intended by Harslev to refer to the supplementary conditions and not the general conditions. So Harslev didn't believe, at least through Mr. Hamilton, that the general conditions applied. He believed it was a reference to the supplementary conditions. In addition, there's an introductory phrase right before those commercial terms appear, and it says the following are negotiable. And so, at a minimum, to the extent that there was some confusion about whether it was the general conditions or the supplementary conditions, and that Green Technologies had been misled by the attachment of the supplementary conditions, then that could have been clarified later under the order confirmation. And of course, Green Technologies testified uniformly that it never would have agreed to an arbitration provision. One final point I wanted to make about the party's performance and the payment. It's pretty clear under Florida law that partial payment does not supply missing essential terms in an agreement. And as the court in Triton noted, parties make down payments for lots of reasons, not necessarily to evidence an enforceable contract, but maybe to further the negotiations as an example of good faith and that they, intend to press forward, which is consistent with Ms. Buchanan's letter of intent that says we want to do the deal, but it's going to be contingent on the performance bond. Thank you.
Thank you, counsel, for your arguments. We're going to have a recess now. Feel free to join us in the rotunda.